the Issam Faris Institute this year at AUB, and one of the ones that we're most pleased to put on, because this is an event that marks several occasions. It's one of the first major events that we're holding in our new program under the International Affairs Program within the initiative to research the United Nations in the Middle East. This is a long-term program that we've now launched that aims to study virtually every aspect of what the United Nations does in the Middle East: peacekeeping, Security Council, sanctions, boycotting Hamas, helping development aid, providing money to UNRWA, helping refugees, all of the things that the UN does. We feel they deserve serious research and analysis and public policy discussions to help the UN achieve its goals, which we firmly believe in. We're big fans of the UN, but we believe that its work in the region needs serious analysis. And this is part of the process by which we study the different organs of the UN, and more broadly, how international norms and international law are actually applied in the Middle East. Are they applied consistently? Are they applied fairly? Are they applied effectively? And this is part of the process. Our international affairs program, the UN initiative, are directed by Dr. Karim Maqdisi, who is also our new associate director of the Issam Faris Institute. He will be moderating the discussion and also giving introductory comments, but we're very pleased to have Hina Jilani and Desmond Travers with us. They are two of the four members of the Goldstone Commission, and they have a tremendous experience in legal issues, peacekeeping issues, which you'll hear from their discussion, their talk, and then the question and answer in which you can ask them anything you would like to ask. And as I said, this is the beginning of a long-term process that we will continue with other research activities, panel discussions, lectures, etc., conferences. We have a major conference planned in October looking at 60 years of UNRWA in the region, which we're doing jointly with UNRWA, and there's other similar activities. So I will turn it over to Karim, and he will guide the process from here on in. Thank you.
Thank you. Thank you, Rami. I'd like to welcome everybody here to the Issam Faris Institute's lecture series on the United Nations in this region. We're extremely excited and delighted to have the two distinguished members of the Goldstone Commission here with us today to answer all our questions and to perhaps clarify a lot of our misunderstandings about what exactly the Goldstone Commission is all about. Very few of us, certainly me, have not read the entire document, which is a rather lengthy legal treatise, but there are certainly a lot of issues that need to be clarified and understood in this region with, I think, a lot of far-reaching implications, not just for what's going on today in Gaza and in Palestine in general, but for Lebanon, for what's going on in southern Lebanon, and for the region as a whole. While I will not comment on the content or conclusions of the report itself, of course, just permit me a few introductory remarks on the Commission itself. The Goldstone Commission, or to give it its more formal title, the UN Fact-Finding Mission on the Gaza Conflict, was commissioned in April 2009 by the UN Human Rights Council in the aftermath of the shocking attacks launched by Israel on Gaza from December 27, 2008 to January 18, 2009. There was widespread media coverage of the events and eyewitness accounts that essentially describe in detail, in vivid detail, the deliberate targeting of civilians and civilian infrastructure that are presumably protected by international humanitarian laws. These attacks by an advanced military power on an adversary with no meaningful capability to retaliate or to defend itself were, in the words of one important analyst, a shocking instance of one-sided warfare. Indeed, the ratio of casualties tells its own story. More than 1,400 Palestinians killed, as compared to only 13 Israelis, of whom only 3 were civilians. Whether the 2009 Gaza war itself can be described as a war as opposed to something else itself is a controversial issue. The UN-appointed Justice Richard Goldstone, the former judge of the Constitutional Court of South Africa and former prosecutor of the International Criminal Tribunals in the former Yugoslavia and Rwanda, to head this mission. The other 3 appointed members were Professor Christine Chinkin from the London School of Economics and Political Science, who was unable to join us today, and the 2 other members who are here today. Ms. Hina Jilani is an advocate of the Supreme Court of Pakistan and a former special representative of the Secretary General on the situation of human rights defenders. And she was a member of the International Commission of Inquiry on Darfur in 2004. Ms. Jilani has received huge numbers of awards, human rights awards, and has been a distinguished voice in the human rights arena, very well known to all of you who read and write about human rights issues globally. Colonel Desmond Travers is a former officer in Ireland's Defence Forces and a member of the board of directors of the Institute for International Criminal Investigators in The Hague. He has also served on a number of peacekeeping missions throughout the world, including in the Balkans, Cyprus, and Lebanon. He was both, he served, and perhaps you might ask questions later, in UNIFIL in southern Lebanon, but also at UNSO, which is the observer mission also located in the region. He was also the military advisor to Amnesty International report when they came after the 2006 war to write their detailed reports on the human rights situation as a result of the 2006 war here in Lebanon. We're very, very pleased to have Ms. Jilani and Colonel Travers with us today, and regret that the other members were unable to join us. In an age of cynicism, I think it is important for all of us to remember that there are honorable individuals in important positions who work selflessly in the fight against injustice on all levels. And I think this is very important for all of us to remember. The Commission presented its findings to the Human Rights Commission in Geneva on 29 September 2009, setting off an unprecedented media frenzy and statements by government officials throughout the world. I will not go into the details of the findings. Obviously, this will be the subject of the panel. But I would like to touch just on the issue of the bitter and perhaps strange, to some of us, strange reaction in Israel to the Goldstone Commission's findings. It's important to understand why the Israeli reaction was so angry and so bitter. Israeli leaders and media in particular waged a campaign to discredit both the findings and the individual panel members. Israeli President Shimon Peres called the report, quote, a mockery of history that somehow lent legitimacy to terrorism. He also launched a scathing personal attack against Justice Richard Goldstone. Prime Minister Benjamin Netanyahu declared that the UN General Assembly, in the UN General Assembly meetings in 2009, that, quote, Israel justly defended itself against terror. This biased and unjust report is a clear-cut test for all governments. Will you stand with Israel or will you stand with the terrorists? The implications for the George Bush speech earlier is obvious. He went on, we must know the answer to that question now and not later. Because if Israel is again asked to take more risks for peace, we must know today that you will stand with us tomorrow. Israeli Defense Minister Ehud Barak called the report, quote, false, distorted, and it promotes terror. He added that adopting the report will cripple the capacity of governments in democratic countries to deal with terror organizations and terror in general. As you know, the Israelis like to use that word. As UN Special Rapporteur Richard Falk, another tireless fighter in the cause of justice, has recently written, the bitter and personal nature of this response by leading Israeli politicians leads us to a core issue at the heart of international politics and international law today, and particularly since the beginning of the war on terror in 2001. And I hope our panel will address this today, namely the suggestion that if an adversary can be characterized as a terrorist, then there should be no operative legal limitations on the use of force. In other words, one of the reasons the Goldstone Commission has been so important and controversial is precisely that it appeared to repudiate Israel's claim that its Gaza operation was legitimate, and this in turn struck directly at the main justification of Israeli violence throughout the occupied Palestinian territories, and not just in Gaza. The Goldstone report, in effect, directly rejected Israel's claim that international humanitarian law must be adjusted to accommodate counter-terrorist tactics, even if directed at targets with heavy civilian components. Of course, the Goldstone report is only words on paper, and like the rest of you, I eagerly await its implementation and look forward to the discussion of how this will be implemented and if this is politically feasible to do so. In the meantime, of course, Israel has continued its blockade of Gaza, a policy of flagrant violation of Geneva Conventions and countless other humanitarian laws. The recent Gaza flotilla, of course, also accentuates why it is so important to address the core issues that the Goldstone Commission addresses. And with this in mind, I'd like, without further ado, to invite our two panelists to describe what the Goldstone Commission report is all about. I think Colonel Travers will begin with this as the military component of it, and then we'll follow with Ms. Jilani. Each will speak for about 20-25 minutes, and then we'll open it up to questions and answers following the discussion. Thank you.
Can everybody hear me okay? That sound about right? Okay, Mr. Chairman, ladies and gentlemen, it's a great pleasure for me to be here with you this evening, particularly to renew contact with my old fact-finding mission colleague, Hina Jilani, who is an inspirational source of advice toward the rest of us on matters of law and on principle, I would say. So I got an education. Thank you very much. It's also a wonderful experience for me to return to Lebanon. It's a strange country. It pulls Irish peacekeepers back repeatedly. I don't know why. My first encounter with Beirut was in 1964. Both Beirut and myself look a bit different today, I have to admit. I'm going to take a slightly different slant on the military aspects of the Goldstone report from the particular view I have applied in the past. I think I'm doing this primarily because I'm in such an august academic institution and because there are issues of academic significance and consequence that have yet to be addressed and need to be addressed, and I would like to highlight and raise those. Primarily, the issues that I'm concerned about are doctrinal and theoretical issues that were expounded by various Israeli experts, be they military, philosophical experts or legal experts, prior to the operation that occurred in Gaza from the 27th of December 2008 to the 18th of January 2009, known as Operation Cast Lead. These theories are worth examining again, and I'm going to go through them, and in some respects I'm going to highlight aspects or consequences of them as we found them during our investigation, which findings were called the Goldstone Report. I'm also going to air some theories that were propounded post-report because they were theories that seemed to gain in popularity and were used primarily to justify the Operation Cast Lead or to denigrate or criticize the report that we were involved in preparing. So I'll start off, and I'm going to read largely from my text because it's a paper in being from my own defense journal, and I actually want to see how it works with yourselves as an audience. You're a test audience. The IDF operations against Hezbollah in Lebanon in July-August of 2006 were considered to have been a failure. The IDF lost some 50 armoured vehicles in engagements in South Lebanon when they encountered anti-armoured directional improvised explosive devices, IEDs. Amongst the vehicles that were lost were reputed to be 4 Merkava tanks, and this is a very, very significant figure. It's also a very significant shock to the armoured units in Israel that such a thing should occur. During the former conflict, great destruction was inflicted on the Lebanese infrastructure, as you know. Among the habitations destroyed were the apartment complexes in South Beirut. The district Dahia, if my pronunciation is correct, gave its name to a new IDF doctrine which was to be applied to future military operations. The Dahiya Doctrine is best described in a statement announcing it by the General Officer Commanding of the Israeli Northern Command, Major General Gabi Eisenkot, when he states, "What happened in the Dahiya quarter of Beirut in 2006 will happen in every village from which shots are fired upon Israel. We will use disproportionate force against it, and we will cause immense damage and destruction. This is not a recommendation. This is a plan, and it has already been authorized." The intentions of the Israeli authorities were further signaled in a paper by Colonel Gabriel Simoni when he wrote in the Institute for National Security Studies the following: "With the outbreak of hostilities," this is future hostilities, "the IDF will need to act immediately, decisively, and with force that is disproportionate to the enemy's actions and the threat it poses. It aims at inflicting damage and meting out punishment to an extent that will demand long and expensive reconstruction processes. Such a process will create a lasting memory among decision makers, thereby increasing Israeli deterrence." The Israeli Minister for Foreign Affairs, Tzipora Livni, the day after Operation Cast Lead, also added as follows: "Israel demonstrated real hooliganism during the course of the recent operation, which I demanded." These statements may explain the disregarding of the stated mission of OCL, Operation Cast Lead, namely the elimination of Hamas' capacity to launch rockets into southern Israel and the elimination of its military structures. They do not, however, explain the emphasis on risk aversion. I repeat that, risk aversion, and the disregard for the safety of non-combatants. The ground incursions commenced on the 3rd of January, as I've mentioned, produced a slew of incidents that were to be the subject of inquiry by the Goldstone report. These incidents were in the realms of hostage-taking, human shields, the shooting of non-combatants, seeking quarter, that is, non-combatants who bear white flags offering no threat, the refusal to permit ambulances to collect wounded non-combatants, unlawful detention and interrogation, the targeting of persons in streets or in places normally accorded shelter status under the conventions, such as places of worship, hospitals, ambulances, UN facilities. The incidents of hostage-taking, human shields, and of the shooting of persons approaching IDF positions in particular gave rise for concern. The actions of the troops in all IDF sectors were similar, and indeed the nicknames and terms they used for these procedures were common to all three sectors. I should point out there were 3 attack routes into Gaza. On the north was by an airborne brigade, on the west by the Golani Brigade, and the southwest by the Givati Brigade, and all 3 brigades were supported by an armoured brigade and special engineer commandos who were trained in disabling booby traps and improvised explosive devices. For example, the use of a civilian as a human shield in order to enter a building known or suspected to be harboring Hamas operatives or to have been booby-trapped was called the good neighbor or Johnny principle. So that was a standard expression used by all 3 forces entering Gaza. All persons, regardless of age or gender, were considered suspect or indeed hostile. A person approaching a checkpoint waving a white flag using a mobile phone was to be shot on sight. The question, what gives rise to rules of engagement that demanded of soldiers such an aversion to risk that they were disposed to behave towards non-combatants in such a reckless manner? To find an answer to this question, we must go to the writings of Professor Asa Kasher, who is Professor of Professional Ethics and Philosophy at Tel Aviv University, and Major General Amos Yadlin of the Military Intelligence Directorate of the IDF headquarters. They wrote an essay called Assassination and Preventive Killing in 2005. The essay raises the issue as the title suggests, but in the essay they also pose a question, and the question was, what priority should be given to the duty to minimize casualties among the combatants of the state when they're engaged in combat against terror? In answer to this question, it is suggested that in the war on terror, their term, the Geneva Conventions are outmoded and no longer suit a state's efforts in combating terror. They go on to argue that a state has a moral duty to respect its citizens' rights more than it respects the human rights of those who are not its citizens. Further, a state does not shoulder responsibility for regular effective protection of persons who are neither its citizens nor under its effective control. In the case of the combatants of a state engaged in confronting terror, they argue that placing a low priority on their safety is immoral. They go on to argue, a combatant is a citizen in uniform. In Israel, he is quite often a conscript or on reserve duty. His state ought to have a compelling reason for jeopardizing his life. The fact that persons involved in terror are depicted as non-combatants and that they reside and act in the vicinity of persons not involved in terror is not a reason for jeopardizing the combatant's life in their pursuit. Where the state does not have effective control of the vicinity, it does not have to shoulder responsibility for the fact that persons who are involved in terror operate in vicinities of persons who are not. I presume you're now getting the drift of this argument. Avishai Margalit and Michael Walzer in the New York Review of Books offer the view that the essay I've just mentioned, went far beyond its academic significance and state that the guidelines suggested in it were indeed the ones that govern the IDF's conduct in battle, and in particular in Operation Cast Lead in Gaza. This assertion has been confirmed in an article in Haaretz by Israeli officers. I have to be honest and say some Israeli officers have also denied this assertion. The coincidence of rules of engagement across all of the three operational zones that I've mentioned, in which troop safety was paramount, to the evident detriment of the civilian population, was a recurring factor that may be deduced from the witness statements during the fact-finding mission's hearings. Such a coincidence is evidence, in my opinion as an ex-soldier, of prior training and prior rehearsal, which in turn is likely to have derived from doctrine, prescribed doctrine. The Kasher and Yadlin argued that the safety of one's own troops takes precedence over the safety of civilians. That is, in essence, what their argument is. This contention, and I have to say it, it's obvious, this contention is wrong and dangerous, as it blurs the distinction between combatants and non-combatants. What is also troubling about this theory, and this is why I particularly want to mention it in an academic environment such as this, is that there is an absence of refutations or challenges to this theory and much less discussion on it in law journals of record. I find that very curious. I find it very curious indeed. In addition to the arguments in favor of discarding or bypassing the Geneva Conventions when engaged in counterinsurgency warfare, a term intended to further argue for relaxation of the conventions came into use. Asymmetric warfare, it was suggested, argued for relaxations of the rules of governing the protection of non-combatants in such a conflict. This word was used on various occasions when discussing Operation Cast Lead or the Goldstone Report. Used in such a context, it was applied to arguments in defense of Operation Cast Lead or as a critique of the Goldstone report. I am personally totally opposed to the word asymmetric. It has never been defined. I have never found it in reputable military doctrine or in reputable military journals. There is no agreed definition for it. An example of its use can be found in the US Army Marine Corps Counterinsurgency Field Manual, when it's argued just once that insurgents by their nature are an asymmetric threat. So it appears just once in a reputable military manual. And even that troubles me, because when would you ever get an insurgent who is a symmetric threat? Please tell me if you find such an animal. So I think the word asymmetric is tautological and is designed to confuse debate. Essentially, the word in its original form was used to highlight the significance of disparities between opposing forces, qualitatively or numerically, and how such a disparity could be overcome or indeed contribute to the defeat of the force with a perceived advantage. The English longbowmen defeating the French knights at Crécy in the 14th century seems to be the classic example of this kind of asymmetric thinking. Users of the asymmetric argument in the context of counterinsurgency seem to argue for the relaxation of the laws of war when engaging insurgents who operate in an urban environment. For how else, they argue, can one neutralize insurgents in an urban setting? Overlooked in this argument is the fact that modern armies now possess precision targeting systems undreamt of some years back. Spokespersons for the Israeli Defense Forces confirm that 90% of the munitions used in Gaza were precision guided. Moreover, anti-personnel munitions can have their warheads designed to limit the radius of destruction much more precisely, thereby reducing the possibility of collateral damage. This argument about asymmetric warfare demanding relaxations in the laws of war to hit non-combatants ignores the fundamental rule of counterinsurgency warfare doctrine, which emphasizes the primacy of people over terrain. Manuals and doctrine on the subject that I've studied are replete with statements asking readers and practitioners to observe the rules which emphasize hearts and minds, and to separate the insurgent from the people as one would separate a fish from water. Indeed, one of the better, but by no means unique theories in its advocacy of fighting for the support of the population in the modern world is Britain's United Kingdom General Sir Rupert Smith in his book, The Utility of Force. In it, he argues that the modern variant is now a war amongst people. General Smith strongly advocates the application of the rules of war when engaging in counterinsurgency warfare. Such rules coincide with the best practice and eschew the notions implicit in the asymmetric view, which argue for the application of unrestrained technologies in the hope of defeating an ideology. I'm going to repeat that again. Which argue for the application of unrestrained technologies in the hope of defeating an ideology, because we have examples of that practice elsewhere in the world at the moment. The Kasher and Yadlin theorists have offered a critique of those who have since put pen to paper to condemn Operation Cast Lead incidents during it. The critique uses the term lawfare to deride these findings by arguing that there is an over-reliance on the Geneva Conventions, all for the purpose of hampering Israel's right to its security and the means it employs in achieving it. The lawfare argument is considered to be an offshoot of the asymmetric warfare argument, in that it is a means of further inhibiting a state's range of actions or by imposing limits to those ranges of actions. Again, very troubling, this lawfare theory is not challenged in journals of record. It stands, and it is of itself evidence of the influence of the original theory of Kasher and Yadlin, which may indeed have inspired it. The Goldstone report, while concentrating in the main on military operations, raised the issue of the blockade and its continuation to this very day. The report discussed and found against, of course, the Dahiyya doctrine. It found the actions taken by the Israeli Defense Forces to be disproportionate, and that the operation departed from its declared mission in order to exact a punishment on the people of Gaza. With regard to the doctrine that presumed to have legitimized rules of engagement sanctioning risk aversion to the detriment of the civilian population, the Goldstone report examined various incidents by type and again ruled against all such incidents. I would like to refer for a moment to the use of weapons and to use of certain kinds of weapons, which were the subject of considerable consideration by the Goldstone report. And those in particular which were very troubling was the use of white phosphorus, the use of devices, darts called flechettes, and the use of tungsten shrapnel in one of two forms, either as shrapnel in the accepted sense of the term, small cubes of 3 to 4 millimeter diameter, or in powder form, which may be mixed with an explosive in a device or a warhead called DIME, dense inert metal explosive. And the use of these has had enormous consequences for survivors. And it's troubling because these devices are legitimate under the conventions, and it is our view that there should be a moratorium on their use, and it is further, based on further research that I've done and others have done, we would argue that these devices should be removed from the arsenals of the armies of the world forthwith. Let me just give you a short example on this. We removed white phosphorus from the arsenals of my army in the 1970s because we saw it as endangering wildlife on our artillery ranges. Nevertheless, 3,500 artillery shells jettisoning 400,000 wedges of white phosphorus were seen appropriate to drop over a densely populated area in Gaza. Give you another example. After World War II, the Royal Navy of the British Armed Forces deposited or dumped at sea in the Irish Sea unused white phosphorus projectiles, absolutely legitimate, entitled to do so. Some years ago, in the 70s, almost 50 years later, beaches on the east coast of Ireland started catching fire and endangering the lives of those who were resting or availing of their leisure time on those beaches. And explosive ordnance officers were called out to examine what had happened, and they discovered that the projectiles dumped post-World War II had broken through their containing chains or bindings, floated onto the Irish Sea, and with the heat of the sun and the corrosion of the metal, the white phosphorus ignited. It is a highly volatile, highly toxic, dangerous material. It is, however, the findings under the heading Attacks on the Foundations of Civilian Life in Gaza to which I must turn. The question now arising is whether the systemic or seemingly systemic nature of such destruction was above and beyond the doctrines so far discussed, and if so, what was their purpose? The Goldstone report states that the military operations destroyed a substantial part of the economic infrastructure and were the product of deliberate planning and policy decisions. The agricultural sector is a case in point. In this context, the razing of farmland, food processing plants, water and irrigation facilities, and the denial of access to farmland adjacent to the border with Israel is very telling. Post-Operation Cast Lead, much of this destruction was in urgent need of reversal and repair if land were to be permanently secured from desertification, saturation by munitions and their chemical residues, and by sewage, salination or drying out. And that process of degradation of the soil continues for as long as the blockade continues. At the conclusion of our report, we had calculated or been informed that 6,800 dunams of land had been so damaged and in need of urgent attention. That figure is now 20,000 dunams of land. And every time I make inquiries from the agricultural sector, the figure increases. And the buffer zone between Israel and Gaza has increased from 300 meters in some instances to 1,000 meters because with the removal of citrus trees by bulldozers, the range of fire of the machine guns on the Israeli side has been extended from 300 meters to 1,000 meters. Taking the most arable land out of the food-producing equation, we now have a figure estimated at 30% of the arable land of Gaza, which is gone or not available. The leading academic specialist in Gaza, Sarah Roy, a Harvard scholar, and interestingly, the daughter of Holocaust survivors, has written, Gaza is an example of a society that has been deliberately reduced to a state of abject destitution, its once productive population transformed into one of aid-dependent paupers. After Israel's assault, Gaza's already compromised conditions have become virtually unlivable. Livelihoods, homes, public infrastructures have been damaged or destroyed on a scale that even the Israeli Defense Forces admitted were indefensible. In Gaza today, there is no private sector to speak of and no industry. Most productive activity has been extinguished. 96% of Gaza's population of 1.4 million is dependent on humanitarian aid for basic needs. Based on such an assessment, it is fitting to describe the blockade as the continuation of the war by other means. I repeat that. It is the continuation of the war by other means. It seems also that the war's strategies were rewritten to meet certain ends, and that these ends, even though written, have been exceeded. It also seems clear that the continuation of the blockade constituted an additional tactical phase to the 4 phases that I presumed occurred during the occupation of Gaza by the Israeli Defense Forces. The first was the bombardment phase, the second was the ground attack phase, the third was the containment and destruction phase, the fourth was the exit phase with further destruction of the agricultural infrastructure. They were the 4 military phases, and now we have a 5th phase, the blockade. It remains a matter of speculation as to what was the ultimate purpose of Operation Cast Lead. I leave that to you to decide. Thank you very much.
Center for Public Policy for giving us this opportunity to talk about the Goldstone report, which has excited a lot of interest and at the same time a lot of opposition from certain sections of the international community and obviously from Israel itself. Let me state at the outset that it was a privilege to work with my colleagues who were on the commission. And I can say to you, Desmond, I've learned much more from you than you could possibly have learned from me. But I think it was an important event. And I say this especially for those who are UN skeptics, that let us face the fact that this fact-finding mission was set up by the United Nations. What we have said in the report is attributed to us, but at the same time, it is a part of the United Nations records. However much anybody tries to push it under the rug, it will not go away from the records. The records cannot be erased in that manner. What the Goldstone report has said will always be important, will always be a part of the record that shows what has and has not been done by the United Nations on issues of peace and security that affect not just this region, but almost the whole of the world in different ways and in different manner. It is in this context that I find that whether the recommendations of the report are fully implemented or not, it still remains an important document. And I hope that one of the significance of this document will be a further development in the honest and intelligent application of international law to situations that occur all over the world. With regard to the terms of reference or the mandate that the Goldstone report was given, I think it is important to understand that the mandate was for the investigation of incidents that had occurred during the war in Gaza. I think the time frame has already been stated by Desmond. But the important thing for us also was that the mandate did not limit us to the 28 days, how many? 28 days of the war? 20, yeah, about that much. It didn't limit us to that because the mandate very clearly said that this is the period from 27th of December 2008 and to the 18th of January 2009, whether before, during, or after, which meant that we took the historical context. We were also able, the report was released in September and we finished writing it sometime in August. So we were also able to say which are the violations that continue to happen. So I think that in itself was something that allowed us a slightly broader scope than most UN missions would have in terms of the temporal mandate that they would, or the temporal scope of their work. The other thing that I would like to say about this exercise or the work that the fact-finding mission did was that for us, the civilian population, whether in Gaza or in southern Israel, were the focus of our attention. Remember that our mandate was to investigate the conduct of war, the way that the war was being conducted. Our mandate did not require us to go into the question of whether the resort to force by either party was legitimate or not. So that was not something that we had to go into in detail in the report, although we did take that matter up, and I will talk about it in a little while, in a very different context. So whatever we had to assess with respect to the consequences of any action that resulted in harm to civilians. Having assessed that, or having come to a conclusion that there was harm to civilians, we then had to assess whether that harm ensued from deliberate and intentional actions to hurt the civilian population. What was the normative framework? For us, the normative framework was the general international law, the Charter of the United Nations, international humanitarian law, and international human rights law, and also international criminal law. Every action or every incident that we investigated, after establishing facts, we had to apply the whole, in a very comprehensive way, we had to apply the international law wherever provisions of the different statutes or the different conventions were relevant. Let me say here, and I'm not taking a defensive position here, but just stating the fact that everything that we say, all findings and conclusions of this report are based on facts, not on opinions or speculations. we relied largely on information that we gathered firsthand. We visited Gaza twice. We inspected most of the sites where incidents that we were investigating had happened. We spoke to eyewitnesses. We spoke to different sections of the society. We verified every bit of information we got from different sources. And on the basis of the common facts that were given to us, we were able to establish what the facts were. Of course, the important thing here also is how far we received cooperation from all parties concerned. Israel had refused to give a cooperation very early in the work of the mission. We were told by the Israeli authorities at an official level that they would not cooperate. The lack of cooperation from Israel didn't just mean that we would not be able to get their side of the story, but it also meant that we would not have access to several Israeli victims of rocket attacks. We would also not have access to the West Bank, where several human rights violations occurred during and in the context of the Gaza operation. So these were two major problems that we confronted because of the lack of cooperation. We, of course, had a problem getting into Gaza and finally were able to negotiate with the Egyptians because Israel had refused us access to Gaza. On the other hand, we did receive good cooperation. I'm not saying absolute and excellent, but we received good cooperation from the Palestinian authorities and good cooperation from the Gazan authorities. But despite the lack of cooperation from Israel, which we regret, we can say with confidence that wherever we have given categorical conclusions, they are not affected by lack of information from Israel. We were able to look into several documents, take into consideration several public statements made by Israeli authorities, as well as military authorities. And therefore, it was not as if there was a one-sided exercise or that our conclusions were based on a one-sided exercise. What else did we do? I mean, when there was no cooperation from Israel, we were very keen that we should not deny any victim the possibility of being able to make visible the violations that occurred. So we devised a system of public hearings. We held public hearings in Gaza in order that people may not feel that the mission was not accessible to them, or because of any reason or any limitation they could not approach us. So there were public hearings. Victims, eyewitnesses were given a priority, but also expert opinions were a part of the public hearings. We held a public hearing. We held hearings, not a public hearing, but we held hearings in Jordan, in Amman, because there were several people who wished to give information from the West Bank and who could not come to Gaza and meet the mission, or even leave the West Bank to come to Geneva sometimes. We also held public hearings in Geneva for victims from Israel and made arrangements to bring them to Geneva so that they could put their case before the mission. And I'm telling you all this in order to assure everyone that whatever was possible to do in order to ensure ourselves that all information will be taken and that we do not remain unaware of any aspect of the mandate that we have been given to investigate. I think Colonel Travers has in a great deal of detail, given you the historical context. Let me say, of course, that we cannot take the Gaza war in isolation, or what has been happening and what has been consistently happening in the West Bank, but also with respect to Gaza. One of the issues in the application of the law was this whole question of the legal status of Gaza. We applied the law after coming to the conclusion, in view of the relevant law, that Gaza is still an occupied territory. And I would like to take a minute to tell you why we came to that conclusion. After the withdrawal of the Israel withdrew from Gaza and evacuated the settlements, I think it was 2005?
Yes.
September 2005. Israel declared that there will be no basis for claiming that the Gaza Strip is occupied territory. I will not go into the legal details, but just to bring to your attention that the legal framework that is applicable to situations of occupation is very clear on the whole question of when does occupation end and what is the legal definition of occupation. Occupation does not need, and I'm saying it in very simplistic terms, otherwise it will take me a long time to explain the law. Occupation does not require the actual physical presence of the occupier in the land that is occupied. If the level of control of the occupier persists even where the occupier is not, or the occupying force is not physically present on the territory that's under occupation, the occupation is said to continue. And this is something that the International Court of Justice has held. It is also something that the Criminal Tribunal for the former Yugoslavia has held in the Nelatilich case, where the trial chamber applied the test contained in Article 6 of the Fourth Geneva Convention, and said that the protections provided for in the Fourth Geneva Convention become operative as soon as the protected persons fall in the hands of a hostile army or an occupying power, this being understood not in its physical sense, but in the broader sense of being in power of the hostile enemy. If you look at the situation in Gaza, even now, not just in 2009, even today, Israel is in effective control of Gaza. It controls the airspace of Gaza. It controls the territorial waters around Gaza. It controls what comes in and goes out of Gaza, so much so that Gazans said to us that what we eat tonight or what the menu is going to be in our homes at night will depend on Israel. They control water, they control all kinds of sources, telecommunications, electricity, sewage networks, and even the population registry, which is the most significant one, the most significant thing that they control, which makes it easier to interpret and apply the law and to say that Israel is still in control of Gaza. Withholding tax and revenue collections, control of movements of goods to and from Gaza, power. These are some of the reasons for which the mission came to the conclusion that since all this control is still exercised by Israel over Gaza, it is still in effective control of the territory of Gaza, and therefore Gaza remains under occupation. Of course, our conclusion is well supported by UN Security Council resolutions, by the United Nations General Assembly resolutions, and by the resolutions of the Human Rights Council. Now, of course, the other issue that remained before us was the determination of the Hamas and the Gazan authorities, or their status. We were satisfied, after having seen the situation in Gaza, that Hamas does exercise de facto authority over Gaza. It is in control of governance. It is in control of providing Gazan residents with the facilities, amenities, etc., that any government would have the responsibility to do. But that was only one aspect. The other aspect was the armed groups. And how do you look at this situation and the Israeli claims with regard to the reaction, or the Israeli position that their mode of fighting or conducting the war was really, by and large, determined by how the Hamas and other armed groups are carrying out the resistance. One thing I think I should say, and which usually people rather avoid talking about, is the whole question of international law not being sufficiently equipped to deal with non-state actors. I don't believe this. If you look at the Geneva Conventions, whether it is the first Geneva Convention, second, or the third, armed resistance groups are mentioned. International law is very clear also on the right to self-determination. Remember, this is the first right that the Charter of the United Nations talks about. It is also a right that both the Civil and Political Rights Covenant and the Social, Economic, and Cultural Rights Covenant talks about in the Common Article. So it is an absolute right. International law does not hold resistance to occupation as illegitimate. Nevertheless, those who are conducting activities as a part of armed resistance against occupation, colonialism, or in the exercise of the right of self-determination must also respect international law. And that, I think, is something which is important to understand. So the whole question of whether the resistance itself is legitimate or not, I think is fairly answered, well answered by the international law. But whether groups that commit violations and serious violations of international law in the course of that resistance are liable under international law to respect it, this most people seem to think that this is a gray area. Please believe me, it is not. It is absolutely important to understand that the international law would apply. There may be more innovative applications required to enforce non-state actors or to hold non-state actors accountable, but it is not absent from international law. So this is something that we were therefore had to look at also in terms of what we found as violations in Gaza, and if they were attributable to armed groups, including Hamas, then we would have to make sure that those parties also understood that they were as answerable as any state would be. Nevertheless, there is a difference. A state who is not only a member of the United Nations, but is a state party to the Geneva Conventions, certainly their responsibility, their obligations are much better defined and much easier to apply and to enforce. In that respect, there might be a little bit of a difficulty or more of a challenge there. But this also is important in the context of what is called the balance. Let me assure you that not for a minute did any four of us, and any one of the four of us, think that there was a balance in this situation. Not only because of the status of the parties, but also with respect to the capacity to harm. And we do believe that there is a lot of difference. But at the same time, the responsibility to hold every perpetrator to account, I think, is a responsibility that vests with anyone who is tasked by the international community to look into these incidents. I will go into some of the findings of the Commission with respect to the broader areas in which violations occurred. And let me say here also that while I talk about these, it will not be possible to look at to give you examples of individual cases or many examples of them, because there were several. We investigated, I think, more than, how many incidents were these? I think 36 in specific incidents, but we had information of more than 100. So it will not be possible to do that. But let me say here that while I am telling you all this, I am mindful of these individual cases where children were shot at point blank, young men were crippled for life, mothers saw their babies die in their arms while they were fleeing from the terror that was pursuing them. People lost not only lives, homes, livelihoods, sources of water and food. So what I'm going to say in the next 3 or 4 minutes is just a very, I would say, mundane narrative of violations, but behind this are terrible stories. I have been in this field of human rights for almost 35 years. I come from a region and from a country where, working as a human rights defender, I see terrible things and terrible sufferings. I have been a part of international missions. One of them was in Darfur. I have seen these terrible states. I was absolutely traumatized when I was in Gaza. And it's not as if this is the first time that I have been to the region. When I visited Israel and the West Bank in 2005 in my press conference in Jerusalem, I said, I've always thought and I've always supported the Palestinian cause, but you have to go there to really understand the suffering. I said, I am absolutely taken aback by what the reality is over there. Let me say that when I went to Gaza, this seemed to be a very mild statement. So please excuse me when I just go through the list and don't mention that, but I wanted you to know that this, everything that we saw, that can't be narrated here in this meeting. But it is there, and I'm sure that if you read the report, we have been able to portray the scene fairly accurately. What we found were the nature of the violations were there were deliberate attacks against civilians. There were deliberate attacks by the Israeli armed forces against civilian infrastructure. There were deliberate destruction of farms and factories. We believe that the destruction of the farms and the factories indicate an intention on the part of the Israeli state to starve the people of Gaza, to narrow down their and diminish their sources of food and sustenance and everything that is required for people to live in a dignified manner. And let me say here also that when I was speaking about the individual incidents, one thing that hit me most strongly was that when we are talking about the violation of human rights, the worst violation that occurs every day in that region, whether it's in Gaza or in the West Bank, is the violation of the right to human dignity. And that you see in everything that you can, witness in the way that the Palestinians are not just treated by the IDF wherever there is interaction between the two, whether it is at checkpoints or anything, but the way that they are forced to exist, the level of destitution into which they have been brought, I think is perhaps the most visible manifestation of the violation of the right to human dignity. Killings of civilians took place not only as a part of the Israeli airstrikes in the beginning of the Gaza operation. Most deaths occurred amongst the civilians, or many deaths occurred amongst the civilians after the ground invasion. I think one of the cases that really caught the headlines in the world was that of the Simoni family. It's a very, very important case study which makes visible not just the intent to harm civilians, but also the policy behind it. This is a family who lost 29 members. And this happened after the ground invasion, where the Israeli forces had taken over that local area. Civilians were guided or forced into a particular house. And when there were 100 people in one house, this house was bombed. Those who survived the bombing tried to escape. They were fired at, they were shot at by the Israeli soldiers. They were the wounded, Palestinian Red Cross was obstructed, was stopped from evacuating the wounded or later on from bringing the bodies from that site. It was only after 8 days that the medical personnel were allowed access. Several of the wounded at the time of the bombing had already died because of the fact that they could not be evacuated on time. Some had survived, and they had terrible stories to tell of the 8 days in which there were several incidents in which, this is not the only one, there were several incidents in which ambulances were not only attacked, but were prohibited from entering areas where attacks had taken place and from where civilians were asking for help for evacuations, civilians who had been wounded. So these are some of the things that I bring to your notice in order to make it clear that in some respects, our task was not very difficult. Things were so apparent that we didn't have to bend our backs to come to a legal finding on these incidents. They were so apparently violative of every norm of human conduct on the one place, but also every norm of international law. Then there is the whole question of the blockade. And I think I'll finish with that. I think by now, after the more recent incidents, we don't have to really talk very much more about the blockade. I just want to say that this blockade, which has been in place since 2007, even before the Gaza operation, it had seriously affected the capacity and the ability of the Gazans to deal with the crisis that came as a consequence of the Gaza operation. Medical supplies were short already. Medical equipment was already inadequate. Much of the equipment that had needed maintenance could not be maintained. So already they were short of so many of the implements that are necessary to deal with an emergency which results as a part of war and destruction. This blockade had also already created a food insecurity and a food crisis. I remember we were told that by the time the Gaza operation happened, there was only one flour mill that was in operation, Al-Badr. The Israelis bombed that flour mill. I also want to say something about my personal admiration of the resilience of the people of Gaza, but also the fact that given these conditions, we did not hear of riots amongst the civilian population, either food riots, or there were bread lines, we were told, because bread had become scarce. We did not hear of any riots that had taken place because of lack of bread or of food. Humanitarian agencies said there was a dearth of food, but distribution was peaceful. And so these were the positive things that I would like to say, that amidst this death and destruction, there were things that you could feel good about as a human being. The impact of the blockade. So I was saying before the Gaza operation, things were bad enough. Because of the Gaza operation, things have become worse. So you can imagine what we saw in 2009 is perhaps much worse now. And therefore, the urgent need to ensure that this continuing violation of human rights, we have classified this as collective punishment in the Goldstone report. We have come to the conclusion that the Gaza blockade is a part of the policy of collective punishment of the people of Gaza by Israel, apart from the other categorization of this action as violations of other provisions of international law. I want to talk just for a minute about the accountability. What was the purpose of the Goldstone report? The purpose, of course, was to ensure that impunity for violation of international law and the harm that is inflicted on civilians should be eliminated. We have made recommendations on how the international community can go about using international accountability systems and systems of justice to ensure that those who have violated international law are held accountable for the actions and to the extent to which they have violated these laws, whether it is the armed groups or the State of Israel. We've been confronted time and again with this argument that it should be internal responsibility of the Israel government to hold these investigations. The principle is that yes, there should be internal investigations, and that's the first thing that we resort to. But if there is no willingness or no capacity to hold independent, impartial, and objective accountability and investigations, then the international system must be used. Let me state here that the Goldstone Mission, the fact-finding mission in Gaza, had very serious concerns with respect to Israel's ability to hold, or willingness, not just ability, willingness to hold objective, impartial, and independent investigations. Several times I have had these arguments with my colleagues in the legal community, saying the principle of complementarity is absolute. It's very important. Fine, I have no problems, or I have no argument with that. But I want to draw your attention to Article 17 of the Rome Statute of the International Criminal Court. And I think that's pertinent because I'm trying to make this point that even in the international justice system, they keep insisting and they keep repeating, whenever the principle of complementarity is voiced, parallel to that are words like unable and unwilling, principles of due process recognized by international law and therefore conforming to those standards, or if the intention is to shield the persons concerned from criminal responsibility, or if there is unjustified delay in the proceeding of investigations, or if these proceedings are not being conducted independently or impartially, then complementarity gives way to the international system. And I think in the case of Israel, it is absolutely true. In the case of the Gaza authorities, we found no evidence that any system of public monitoring or accountability was in place or was exercised to ensure that actions in conducting armed resistance by the occupied population or groups responsible for that resistance, that if violations had occurred, there had never been any investigations. But that was not all. We also found that with respect to the Gaza authorities, there were more serious concerns with regard to the violation of human rights of the population of Gaza. We found torture, we found arbitrary detentions, we found that there was a conduct by the Gaza authorities